what's your answer to the other part of this, which is the states do you dispute that the states have consented? I know they're not the ones that are being bound, but the first step is, did they consent to follow RLUIPA?
I have to be very precise about this, Your Honor. Yes, the state consented to RLUIPA's plain terms.
When it accepted the money, it did.
That's exactly right. And my friends love page 46 of our red brief. What we're saying there is that when a state official in his official capacity is working on the job, he is the state under this court's common division between official capacities and individual capacities. And of course, state officials in their official capacities as the state are bound by RLUIPA.
I'm sorry, are you saying that this individual who represents the state, on page 46 of your brief, you said he's bound by this statute, correct? Substantively as an official of the state.
In his official capacity, of
as
course.
A state.
He is the state.
So he is the state.
He is the state.
So you say it's enough knowledge for him to know what the law says and that he's working for the state and he represents the state, that he can't violate the law, correct? And then if an injunction issues, he could be held liable for violating that law, correct?
Because it's an injunction against the state, Justice Sotomayor.
But you're saying at the same time that person who, the warden, who is cutting the individual's hair, should know that that's a violation of the state for which an injunction should be liable, but he shouldn't know that he's liable for personal damages too. That's what you're saying.
Your Honor, that's what 10 federal courts of appeals have said.
Well, that's what they said, but as the other side pointed out, they didn't start with the first question, which is it this statute clear that there's an individual a cause of action? Yes, it does make that clear. And is it clear by using appropriate damages clear that it includes appropriate relief that includes contract damages? In Tanzan, we said yes. So whether they're right or wrong, it's irrelevant. If we assume that the law says what it says, how do we say that official acting as a person knows one thing is wrong for the state, but it's not wrong for him to do, or her?
So Justice Sotomayor, I think that goes back to an earlier question Justice Alito asked of the federal government, which is, what perspective are we looking at? I was surprised to hear the federal government say, you look at the time of enactment when Arlington Central, Justice Alito's opinion for the court, and then Cummings, the Chief Justice's opinion for the court, said, you look at when the official is deciding whether to receive federal funds, what would that...
Frankly, that would mean that, do you know when they took, I thought federal funds came every year.
And that's my point, Justice Sotomayor.
So every year they know that they're bound. So does it make a difference if we say it's clear enough, but it wasn't clear to them at the time they took this action because 10 circuits were wrong, but moving forward, it's clear enough to anybody else that they shouldn't do it?
That's the very last argument we put in the red brief, Your Honor, which is if you disagree with everything else I say about the constitutional questions, then that, I think, has to be the answer. And I will say it's not just what has happened
between... It's a form of qualified immunity you're arguing.
What I'm saying, Your Honor, is that between the year 2000 and Tanzan, I think certainly we have this huge body of RLUIPA precedent that would have put no state prison on notice about prison officials being liable in their individual capacities.
How many of those cases were post-Tanzan?
We have
Tanzan was 2020. We have this case, but how many of those were post-Tanzan?
I believe we have about 4 circuits post-Tanzan, Your Honor, and that includes Chief Judge Sutton in Ali versus Adamson. That includes Judge Sullivan in the Tripathy case out of New York. And the other thing I was going to add to that answer, Justice Sotomayor, is that I'm happy to rely on the body of RLUIPA precedent, but in the spirit of footnote 6 in Sosamon, which looked at pre-RLUIPA precedent, we have 4 federal courts of appeals even before RLUIPA saying this sort of cause of action for damages, that's not a thing under the spending clause.